panel for any questions and do our best to answer them in real time as they come in or in the Q&A section of the agenda. Okay, so it's 1:05, so I think we ought to get going. Not everybody who's signed up is here yet, but folks will hopefully join in as we get started. So my name is Sybil Hebb, and I'm a policy advocate with the Oregon Law Center. And I'm going to introduce my colleague, Becky Strauss, who is a fantastic staff attorney with the Oregon Law Center's Portland office. And I see that Kate Gonzalez from the Oregon Housing and Community Services Department is joining us. And I think Laura Lean from OHCS is also going to be joining us as she's able after finishing up a prior meeting. So I'll give folks a chance to introduce themselves individually as we get going, but I'm just going to give you a quick overview of our agenda and then kick it over to Becky to get started. And then I will go into the Q&A to answer questions as they may come in. And so the Law Center was really grateful to get to work with our partners at OHCS, as well as so many of you on this call and many advocates and legislative leadership to try to address concerns about stability for tenants as the moratorium on evictions for non-payment comes to an end. So there are two bills that we'll be discussing, Senate Bill 282 and Senate Bill 278. There's also recent federal action with the CDC moratorium that we're going to discuss. And we've divided the agenda up so that we will talk about the substantive policy issues. Becky's going to handle that. And then we will take a pause for some Q&A. And then we will turn it over to our fabulous partners at OHCS to talk about the immense new rent assistance programs that are available for tenants across the state. And then we will do a Q&A after that portion as well. So I'm going to turn my video off and turn it over to Becky to introduce herself and to get started.
Great. Thanks, Sybil. Thanks, everyone, for joining us. It's exciting to see so many people able to attend on relatively short notice. I'm really excited to be here. My name's Becky Strauss. I use she, her pronouns. I'm a colleague of Sybil at the Oregon Law Center. I'm a staff attorney where I focus primarily on landlord-tenant issues with my clients. I'm also really excited to be here to give an update on these.
Becky, we lost you for a minute. Are you there? Kate, can you hear Becky?
I can. Today seems like it's very technologically challenging.
Okay, sorry. Let me text her and let's just give a pause. Sorry, folks, and thanks for joining. Hang on. All I have to say is that Becky, from my screen at least, is frozen in a much better position than I usually get frozen in. Just got a text from her and she's rejoining now. So thanks everybody for your patience. And while we're giving her a second to get reconnected, this is obviously such an incredibly challenging time, and so much is shifting so significantly. And so we really appreciate it's so fantastic in Oregon. We can get, almost 200 people signed up for a webinar with something like 3 days notice. So thank you all for making that time. And we encourage you to really share all of these materials and post them everywhere you can. And when we distribute them, they will be distributed for your dissemination and use however you see fit. Kate, I'm getting a message that Becky's struggling with some rebooting. Maybe we can start with the rent assistance portion as a foundation. Does that work for you? And then we can.
Sure. I'm flexible and adaptive with these crazy times we're in. Big appreciation to you all at OLC for pulling us all together to talk about this important topic. So again, I'm Kate Gonzalez. I use she, her pronouns. I'm the Senior Communications Coordinator at Oregon Housing Community Services. We provide stable and affordable housing, and our mission is to provide opportunity for all Oregonians and making sure Oregonians secure housing and stay housed. So during the pandemic, we've been providing millions of dollars in rental assistance. These are very unprecedented times, as folks are well aware. For the first time, we've been able to launch a statewide portal for emergency rental assistance. Recently, the US Treasury allocated $204 million to Oregon Housing and Community Services. Those are federal dollars to distribute for emergency rental assistance. And so there's also 5 different counties and the city of Portland who are administering their own programs. I think folks on this call are well aware of the really serious challenges facing Oregonians, many of whom were facing housing instability long before the pandemic, but these challenges have only become more heightened, and especially for communities of color, including Black Latinx communities. I should point out too that the US Treasury allocated separate funds for tribes in Oregon, but our approach is really to have wide open arms, so anyone who applies to the state program is able to be worked with local administrators at the local level. So I'll explain a little bit more about those nuts and bolts, and then later on, kind of at the tail end of today, Assistant Director Laura Lean will jump on in case folks have really nuanced questions. So we'll be really lucky to have her expertise on the line. But for the purposes of today, I know our friends at OLC are going to do a much deeper dive about the moratorium expiring today, which is very serious and has far-reaching consequences for Oregonians. There have been some recent protections passed by the Oregon legislature and signed by the governor, which is tremendously exciting, but these protections, some of which are not automatic. And so in order to be protected, folks must apply for emergency rental assistance. And again, OLC will do a deeper dive into what's called Senate Bill 278. But we're doing all we can to spread the word that Oregonians who may face housing instability or may fall behind on rent really need to just do all they can to apply right away. Getting an application in will provide some safe harbor to folks, that folks can have proof that they've applied, that they'll be able to share with their landlord to demonstrate that they have taken action. And these protections will be expanded to give people those additional 60 days to get some time to get back on their feet. We'll give them time to get the emergency assistance dollars distributed at the local level. Hopefully, there is some really nuanced criteria with prioritization. And so this is not an instantaneous process. Basically, there's different layers of prioritization, but for eligibility, the basics are someone has to be a renter in Oregon. They have to be impacted by the pandemic in some way, shape, or form and make less than 80% of area media income. But in addition to those priorities, US Treasury has encouraged folks to prioritize folks whose incomes are at 50% of the state median income. and even below at 30%. And so the website, which I can share my screen shortly so that you all can see some of the communications we've put together in materials, does have a tenant checklist about some of this basic criteria and eligibility. But in addition to those pieces, there are several different prioritizations. And so the most vulnerable Oregonians will be prioritized first. So depending on the local level, it can take different timelines in terms of how many applications folks are receiving and where folks fall in that spectrum. So I'll just go ahead and plug the website. It's called OregonRentalAssistance.org. It has a whole bunch of different information that applicants can find useful, one of which is the information to click to the ALITA portal. That's the statewide portal where folks can apply. The website is translated into 5 languages. Well, so it's English, Spanish, Simplified Chinese, and Russian. And so I think what might make the most sense now is if I go ahead and share my screen. Let me see, I'm hoping I have the presenter capabilities to do that.
You should have it, yeah.
Oh, good, thanks so much. If folks can bear with me for just a moment. Or does it make sense, Becky, for you to kind of take the mic and then towards the end, I'll do the overview of the website as kind of a sandwich of the presentation, or should I just keep plowing forward with the info right now? Becky?
I say go forward. I'm so sorry, but I think let's just switch the order if that's okay.
Okay, absolutely. So let me just go ahead and do that. Apologies, this is having more computer challenges. Shoot.
Kate, do you want to let us know what the web address is, and I can put it in the chat?
Yeah, it's OregonRentalAssistance.org. And there, I'm hoping that fixes it. The tech challenges of today, right? Here we go. Boop. All right, are you able to see that? Great. So you'll notice that on front and center of the website, we have some information about the importance of applying immediately in order to receive those 60 days of eviction protection, or to at least learn more about that safe harbor information. There's also a tiny bit of additional information about the CDC moratorium that is expiring at the end of July. So no matter what, even if people are applying for that, we still are really encouraging folks to just start their applications and get them in right away for the Oregon Emergency Rental Assistance Program. But there's also information in the different languages that I mentioned, and there's a video, we have information for tenants, then there's also a section for landlords who will be verifying some of the information submitted by tenants. We also have frequently asked questions and a variety of different tools that should hopefully make it easier for folks, including information of a step-by-step video walkthrough of the program. There's information about area media income. There's information about what to gather before you apply. these applications can take some time. So we do encourage folks, if you have access to a computer, ideally to use a computer, you can still submit it over your phone, but it does take time. There are a variety of libraries that are beginning to open, and so some folks might want to research your local library to see if they're open for computer appointments. There's also assistance provided by local providers. Again, the various steps of the program are first to apply through the portal, but over time you'll be connected with your local program administrator, and that's depending on the region you're in. But those local community action agencies, or in one case, a public housing authority, can work with you if you need a paper application or if you need specialized assistance. There's also assistance provided by OHDC and 211 for folks who might be needing assistance in Spanish or in other languages. I do want to point out that in addition to applying to the program, for service providers and other folks on this call, folks may be interested in the incomplete applications. That's another kind of pot of folks that we're really encouraging to get their applications in right away. Sometimes people start an application and then they get pulled to do other things. We've sent out an email encouraging folks to complete their application, but there's a variety of different forms that might make that easier and swifter. There's some self-certification forms if someone might be lacking documentation. There's also other resources to hopefully make that an easier process, including that step-by-step walkthrough of the portal that I mentioned. And so again, there's the frequently asked questions, which can help people figure out some of the basics before they apply. And again, visiting the tenant checklist to get all that information together before you apply. There's also tips for a successful application, which kind of goes over some of the most frequent challenges some people have experienced and ways to make it easier. People often have questions about ways to find out information about the status of their application, and the easiest answer there is to just continue to log back into the system where you'll be able to check the status of your application. And so we are doing a huge push out on social media and contacting various partners to spread the word. And we would really appreciate everyone's help on the call to get the word out about Oregon Emergency Rental Assistance Programs so that additional Oregonians can have these really critical protections. And so as soon as I conclude, I'll go ahead and drop the link to a Dropbox in the chat in case anyone on this thread wants to share some of those social media graphics or flyers. I will point out that there is also additional communications toolkits that are available in the 5 different languages. And so those resources can be found here on the portal. And again, just applying for assistance is as easy as clicking that button and it takes you straight to the website itself. So with that, I will keep things short so that we can turn things back to our colleagues at OLC. But if there's any questions towards the end, I'm happy to take them. Thank you.
Great. Yeah, thanks, Kate. And I think maybe we'll shift it so that I'll do the presentation and then we can combine questions at the end. Thank you so much, everyone, for bearing with me. And to Kate for jumping in and switching the order. I really appreciate that, bearing with the technology struggle. So again, I'm Becky Strauss. I'm an attorney with the Oregon Law Center. I practice primarily in landlord tenant law, and I'm here today to talk about our updates from the legislature, primarily on COVID-related tenant protections as the what has been the non-payment of rent moratorium ends today. What's the outlook going forward? I'm gonna, just before I start, I just wanna make a note that this webinar was targeted toward service providers. I believe that service providers are the people who are primarily participating in the webinar today. And I know there may be a mix here of providers that are serving tenants and maybe some providers that are actually acting as landlords. This webinar is not meant to be legal advice in any form to landlords or tenants, but it's particularly not to be thought of as compliance advice for landlords. I think that there are other fora for those types of conversations, and this is not it. So I'm here today to give some general information about the law. And again, I practice from the tenant perspective, and so am generally advising about how a community partner might work with a tenant in accessing the protections that the legislature has passed recently. So with that, I'm going to share my screen, hopefully without drama, and get started through a number of slides that are relatively dense slides that we will provide to people. So don't worry about furiously taking notes. I did that so that all the resources can also be a written resource after the webinar. So apologies for the dense slides. So here we are on June 30th. This presentation is primarily about Senate Bill 282 and Senate Bill 278. I'm going to adjust my windows here so I can see my slides. So the legislature passed Senate Bill 282 on May 19th. The governor signed that, and most of the provisions took effect right away. Some of them take effect tomorrow, and we'll talk about those. Also on May 19th, OHCS launched the Emergency Rent Assistance Program that Kate has just introduced for everyone. As it became clear toward the end of May and through the beginning of June, that rent assistance was not going to reach the hands of tenants or landlords when it was needed come July, the legislature did a lot of quick work and pulled together Senate Bill 278 to provide what we're thinking of as a safe harbor provision, a 60-day pause for tenants who are at risk of eviction proceedings or are about to be in eviction proceedings, to give them some time to get that rent assistance application completed and processed before moving forward with the eviction process. So that all happened very late in the legislative session, and the governor signed that bill on June 25th. The day before that, the CDC at the federal level acted and extended the CDC moratorium. We'll talk a little bit about that, but really the bottom line for this presentation is that we're not spending a lot of time on the CDC order for a few reasons, but primarily because the protections in Oregon really sort of cover the field and are more protective for tenants given the details of the CDC order. So the key takeaways of this presentation, and again, I appreciate anyone who has attended these trainings in the past. Some of this information is going to be a repeat of the Senate Bill 282 presentation that we gave after that bill passed. This is kind of a combination of those two bills. So you'll see some repeat, which is great for me, hopefully great for you to really, repetition is better to understand these very complex and interweaving provisions. So again, some of this is Senate Bill 282, some of it is 278, but it's all protection for tenants now. So the key takeaways for this presentation today are that the eviction moratorium ends today on June 30th. Several iterations of a moratorium have been in place since COVID started back in March 2020, primarily pauses on non-payment of rent and no-cause evictions. Those protections end today. So beginning tomorrow, tenants must pay their rent in July and going forward or face action for non-payment of rent. Rent assistance is available for those tenants who are unable to pay rent in July and going forward, and tenants should apply for that rent assistance immediately per the information that Kate has provided and that's available on the rent assistance website. If a tenant shows their landlord documentation that they've applied for rent assistance, the landlord is not allowed to evict that tenant for non-payment for 60 days to allow for the processing of the rent assistance application. So that protection is available starting tomorrow for tenants. The grace period for the back rent was extended in Senate Bill 282, and it was extended through February 28th, 2022. So we're now in a legal landscape where current rent and rent going forward is due, but for people who have accumulated back due rent through the moratorium, through the pandemic period, that rent, back rent is not due until March 2022. It's called what we're referring to as the grace period. So the grace period applies to back due rent, which would have been owed from April 2020 through today, June 2021. And landlord can start evicting for that back rent beginning in March 2022. We have a grace period now for tenants to get assistance to get that paid. We've had a scheme, this is just on this, touch on this last bullet point, throughout the year or at different points throughout the year. Most recently, we've had a requirement that tenants submit a hardship declaration in order to access these protections. That hardship declaration is no longer needed. It doesn't carry legal weight. Tenants don't need to learn about it or do anything about it starting tomorrow and going forward. It is not necessary for tenants to access the protections of the grace period or the protections of the 60-day pause. I'll kind of say all these things in several different ways and repeat myself because, again, repetition is going to help us really wrap our minds around it. The eviction moratorium on no-cause terminations ends today, June 30th, 2020. Through the pandemic period, both evictions for non-payment of rent and no-cause evictions have been paused, and both of those pauses are lifted today. So we're now in a legal landscape that is pre-COVID times in terms of when landlords can end a tenancy for no reason, or otherwise known as a no-cause eviction. Those are primarily governed by Senate Bill 608 that was passed in 2019. And generally, landlords can't evict tenants when tenants are without fault, except in these three bulleted situations. If the termination is in the first year of the tenancy, the landlord can give a no-cause eviction. And for those tenancies that would have expired in the pandemic period, when there was otherwise a moratorium on no-cause evictions, landlords now have this unique period of July and August to give a 30-day notice. They kind of get an extra 60 days to give that no-cause eviction within the first year to tenants. In the city of Portland, there are unique protections that those no-cause notices have to give 90 days, not 30. The other reason that a landlord can end a tenancy for no cause, or if the tenant wasn't at fault, is for one of the 4 permitted landlord-based reasons. Those are if the landlord plans to demolish or change the use of the unit, if the landlord intends to repair or renovate the unit such that the tenant cannot live there while the renovations are happening. That's an important caveat that's not listed on the slide, but it can't just be repair generally, but it has to be a repair or renovation that would render the unit unable to occupy. The third reason would be if the landlord or the landlord's immediate family member intends to move into the unit as a primary residence, or fourth, if the landlord has sold the unit to a new buyer who plans on moving in. Again, no, landlords can't give a no-cause eviction in order to list the unit and repair it or stage it for selling. It's only when they've accepted an offer from a new buyer who plans to move in as a primary residence that they can give that landlord-based eviction. Those 4 landlord-based reasons have to require 90 days, and in most cases, a 1-month relocation assistance payment to the tenant. In Portland, those relocation assistance payments are higher. The other situation in which a landlord can give a no-fault or no-cause eviction is if the landlord lives on the same property as the tenant and there are 2 or fewer units. So that's back to the pre-pandemic state of the law in terms of no-cause evictions. There is no longer a pause or a moratorium on no-cause evictions starting tomorrow. There's also similarly no longer a pause on non-payment of rent terminations going forward. So beginning July 1, tomorrow, tenants have to pay current rent for July and forward or face eviction. There's a grace period. So until February 28th, 2022, landlords have to give a 10-day notice before terminating terminating a tenancy for non-payment, and they have to put in that notice that they can't be terminating for the back rent during this time. So that's the grace period that we'll continue to talk about through this presentation, but landlords have to notify tenants that they can't be evicted for the grace period, only for July rent going forward. And for those of you who are used to practicing or advising in this area over time, typically non-payment of rent notices are 72-hour notices. They're now 10-day notices, and they will continue to be 10-day notices until March 1st, 2022, when they'll revert back to being 72-hour notices. I think it's important to just note this last bullet point as well. Landlords can't give a non-payment of rent notice until the 8th day of the rental period. So typically rent is due on the 1st. That means that if a tenant is not paying on July 1, a landlord can't give that 10-day non-payment of rent notice until the 8th. And so we don't expect to see eviction filings in court on these cases until closer to the 19th or later of July, because of the timelines of the way that lines up with the 10-day notice. So also something that is going to impact the volume of cases in eviction court is Senate Bill 278 and the 60-day pause for tenants who have applied for rent assistance. So as I've mentioned, if a tenant has applied for rent assistance and they will be getting some sort of documentation proof from the rental assistance provider that they have applied, if a tenant provides that documentation of the application to their landlord, the tenant cannot be evicted for non-payment of rent for 60 days. That 60 days is from the time that they provide the documentation to the landlord. That's when the clock starts. The clock does not start on the time that they apply for the rental assistance. So there's really an important note there to distinguish. As I said, rent assistance providers in Senate Bill 278 are required to issue those types of documentation. They must provide to the applicant a dated receipt or some documentation verifying that they've applied for rent assistance. And then when the tenant provides that documentation to the landlord, the tenant can do so in a number of kind of a flexible list of ways that they can do that, meant to just achieve actual notice to the landlord. They can give that document over email, they can do a screenshot, other written or electronic documentation from the rent assistance provider, anything that is actually showing that to the landlord that they have the documentation that they've applied for rent assistance. That will trigger the 60-day pause. So when can the tenants make this request to the landlord for the 60-day pause? What we're recommending is that tenants should apply for rent assistance right away and then give the documentation of the application to their landlord when they get a non-payment of rent notice from their landlord. Tenants have until first appearance, and the first eviction court date is called a first appearance. So the latest that a tenant could give that documentation would be at the first appearance court date and any time before. And as I said, we're sort of recommending that tenants don't wait and go ahead and apply for rent assistance right away. And then they don't have to give the landlord the documentation on the day that they apply for the rent assistance. They can give it to them when they are facing eviction through a non-payment of rent notice. So these couple of slides sort of break down a couple points in time where a tenant might be giving the landlord the documentation to request a 60-day pause, and what landlord's obligations are depending on which point in time the tenant gave that notice to the landlord. So here on this first bullet, we're saying after the landlord gives the tenant a 10-day non-payment of rent notice, at that point, if a tenant is giving it after the non-payment notice, the tenant goes ahead and provides the documentation to the landlord of their application before the 10-day notice period is up. And then the landlord is then prohibited from moving forward and filing the eviction case in court. If the rent is still unpaid by 60 days from when the documentation is provided, then the landlord can go ahead and give a new non-payment of rent notice. They can't go straight to eviction court, but they have to give a new 10-day notice, and then they can proceed with the eviction in court. At a later point in time, if the tenant is giving the documentation to the landlord after the landlord has already filed in court, the tenant still has a right to do so. And at that point, the case is paused for 60 days, and the
the case will automatically kind of set over that first appearance date for 60 days out, or at least 60 days out. So it kind of stops the case in its tracks, allows for the tenant to access the rent assistance and for the rent assistance to process and hopefully get landlord paid, resulting in a dismissal of the case. But if landlord is not paid within those 60 days, the court will go ahead with first appearance and go ahead with the eviction proceeding, and that can move forward. Just like landlords have to tell tenants about their rights to the grace period, landlords also have to inform their tenants of their right to this 60-day pause. And so they're required to do so at two separate points in the process. If they're giving a 10-day non-payment of rent notice of termination, they must tell tenant of their rights to the 60-day pause, and the statute provides some specific language that landlords can include that would comply with that notice requirement. And landlords have to do that as part of the complaint and summons if they're actually filing the eviction court case. So again, another situation where tenants are not responsible for just knowing that they have these rights, but the landlords are responsible for notifying tenants that they do have these rights, both to the grace period and the 60-day pause. If the case is already in court when tenant has given the documentation of the rent assistance, or if tenant gave it before and landlord didn't comply and went ahead and filed anyway, courts have to dismiss the cases in these situations. The landlord didn't notify the tenant of the right to the 60-day pause, as was included on the prior slide. If the reason for the non-payment is because landlord refused to participate in a rent assistance program, that's grounds for dismissal of an eviction case. If the landlord receives the rent assistance covering the amount owed, that would result in a dismissal. There's no reason for the eviction anymore. Or the tenant requested a 60-day pause from the landlord before the landlord filed in court, and landlord went ahead and filed anyway, then the case should be dismissed. Those are the Senate Bill 278 protections. I can't see what's going on in the Q&A, but we can address that later, and I'm sure Sybil is furiously reading and responding. So if there are questions about Senate Bill 278, we'll be sure to either answer them here or follow up with answers to those questions. This is the point where I want to make a little note about the CDC order and sort of raise it, describe it, and then again, sort of dismiss it in that it's really not the priority or the strongest protection for tenants in Oregon right now. There is a federal order. It's been in place for quite some time, and Oregon hasn't needed to use it because we've had stronger protections here in Oregon for tenants for non-payment of rent evictions and no-cause evictions. Now that those are lapsing and yet the CDC order has been extended, I think it's raised some questions about whether tenants can and should take advantage of the CDC order. That has been extended through July, and it's, I think, legally possible that some non-payment or no-cause evictions could be halted under that order, but really we're encouraging and advising our clients to be paying attention to Senate Bill 282 and Senate Bill 278 as the stronger protections and not relying on the CDC order. Part of the reason for that is that there's often a misunderstanding about the CDC order, and that misunderstanding is that it prohibits landlords from giving non-payment of rent notices. Really what the CDC order is prohibits execution of the judgment at the very end of the line of an eviction case. And by execution of the judgment, we kind of mean sheriff lockout. And that's, again, it's at the very end of the line. And so when you start to think about the timelines with non-payment of rent cases, as I said before, rent is due July 1. Landlords can't give 10-day notices until July 8th. That means they're filing an eviction case on July 19th. By the time that goes through the process, not even withstanding Senate Bill 278, the case is going to be over by the time the CDC orders will have expired by the time that it's coming down the line to a sheriff lockout. So really the important protection here is Senate Bill 278. If tenants can't pay their rent, they should be applying for rent assistance right away. And if they're getting a non-payment of rent 10-day notice, they should submit that proof of application to their landlord and request a 60-day pause to allow time to process the application. I think at some point I had seen a question about whether the CDC order adds an additional month and kind of has the effect of having a 60-day pause, or I'm sorry, a 90-day pause as opposed to a 60-day pause. Unfortunately, it doesn't work that way. And so really what we're looking at is the Senate Bill 278 60-day pause is the strongest protection here for tenants in Oregon. Okay, so the grace period, I've made mention of the grace period. I'm going to go over it in a little bit more detail here right now. Again, current rent is due in July and moving forward, but back rent that may have accrued through the pandemic period is not due yet. That's for some tenants, a very overwhelming amount of rent debt that is impossible to pay on July 1. And the legislature recognizes that and wanted to provide a grace period for tenants to be able to access rent assistance and figure out their options. And the legislature provided extra time for tenants to do that. So landlords cannot terminate tenancies for non-payment of rent or other housing costs that came due between April 1, 2020 and June 30th, 2021 today. That grace period ends at the end of February 2022. So that back rent is due on March 1, 2022. They can't sue for the back rent or send that to collections during this time. No hardship declaration is required, no income eligibility. These protections are automatic. So a quick little example to help illustrate what the protection means. If a renter did not pay from May 2020 through July 2021, so they don't end up paying this month, the landlord would be able to issue a termination notice for non-payment of rent in July, but only for the 1 month of July. The renter could cure the notice by paying, again, only the July rent within the 10-day notice period, and landlord would not be able to issue a termination notice based on the May and June rent until March. What should tenants do if they've received a 10-day notice for non-payment? We recommend these 4 steps. If after July 1, which is going to be pretty much everyone at this point in time, tenants should first check the dates for the rent that's being sought and remember that landlords can't give termination notices for that grace period rent until the end of February. So make sure that what's being asked for is accurate. Second thing tenants should do if they're unable to pay that rent is apply for emergency rent assistance if they haven't already, through calling 211 or accessing on the website. And then going ahead and at that point with a 10-day notice, tenants should provide the documentation to their landlord of the application for rent assistance to get a 60-day pause and allow some time to get that rent assistance processed and get their rent roll up to date so that they're not moving forward with the eviction. If they have specific questions about their situation, tenants can call Community Alliance of Tenants or Springfield Eugene Tenant Association hotlines. Those are non-legal hotlines with general information for tenants, or they can seek out their local legal aid office if they think they might have legal claims, meaning that there's some peripheral issue in the case other than rent is owed and they're seeking assistance to get that rent owed. They can access, figure out where their local office is based on county by going to OregonLawHelp.org. And there's a map of all the legal aid offices and their contact information. So landlords who violate either the grace period protections, the other parts of Senate Bill 282 that we're going to talk about in a second, or if landlords don't honor the 60-day pause period after getting the documentation from the tenant of rent assistance, the tenant likely has a defense to the eviction in court and has the right to a court order allowing a return to home if they've been, in some cases, if they've been unlawfully evicted. Also, if a landlord evicts a tenant in violation of the law or kind of what they're called unlawful ousters, locks a tenant out or turns off the utilities to force them out, tenants can also get a court order forcing the landlord to allow them back in. In those situations, we would recommend accessing Oregon Law Help to seek out legal assistance. And we'll have those website and also the number for the Oregon State Bar at the end of this presentation. That's all the grace period and the 60-day pause information. There are a couple other additional protections in Senate Bill 282 that I'll go over now before we pause for questions. We talked about this briefly with regard to the grace period, but landlords cannot report debts from April 1st, 2020 to June 30th, 2021 to credit reporting companies. That's at any point, even after the grace period ends. Landlords can't report that back debt to credit reporting companies. And during the grace period, landlords can't sue the tenant for the back due rent until the end of the grace period. It's not just a protection against eviction for that back due rent, it's a protection against being sued or sent to collections for that back due rent as well. And that second bulleted protection that expires at the end of the grace period. When screening prospective tenants for a new unit, landlords can't use the fact that a tenant has unpaid back due rent from April 1 during the application process. And I want to just double check that slide is accurate. I think what the protection is, and Sybil we can chime in and follow up on this in a second, and I'll fix the slide if this is inaccurate. I think that we're talking about that the landlord cannot consider unpaid rent debt from April 1 through today, June 30th, 2021, because that's the back debt eligible period that's subject to the grace period during the application process.
You're correct. That's right.
Is that correct?
Yeah, that's right. It's just the COVID protected moratorium grace period protected debt.
Sorry for that typo. I'll fix it before we post this, before we post these slides. And that protection will end January 2028. So until that time, if a tenant has back due unpaid rent from this emergency period, meaning today and prior during the pandemic year, new landlords can't screen out a tenant because they have back debt that's not owed yet under the law. Landlords also can't consider eviction judgments from this time, and that protection does extend to March 1st, 2022. So it's April 1, 2020 through the grace period. Those eviction judgments, regardless of whether they're non-payment, they could be tenant fault evictions, any type of eviction judgment during this pandemic year and through the grace period cannot be considered by landlords when they're screening new tenants during this time. And that protection does not expire. So in 10 years, landlords will still be prohibited from considering that, although there are other layered protections that would have stopped that consideration anyway. But the point being, it doesn't expire. The other new protection in Senate Bill 282 is a new reason that tenants can get an eviction judgment expunged on their record. These are the 4 bullet points now that are the current law of when a tenant can get an eviction record expunged. The second bullet in bold here is a new one. So it's pairing up with that screening protection that I just mentioned, but it's saying that if the basis for the eviction arose between the pandemic period and the grace period, so April 1 through February 28, 2022, and the tenant has otherwise satisfied any money award that came as part of the eviction, then that eviction can be expunged from the tenant's eviction record. There are additional protections in Senate Bill 282 relating to protections for non-tenant guests. Landlords may not assess fees or terminate tenancies based on guests staying in the rental. So it's kind of a protection against enforcing or evicting tenants based on a violation of what might otherwise be a guest policy violation in non-COVID protection times. A renter can't allow more people to live in the unit than is otherwise allowed by occupancy guidelines from federal, state, or local law. But landlord can't impose occupancy guidelines that are more strict than what federal, state, or local law might otherwise regulate. So if a renter's guest is living in the unit, again, a tenant can't be evicted for a violation of the guest policy, but if the guest is there for more than 15 days in any 12-month period, the landlord can require the guest to be screened and come on in as a tenant. And that guest screening gets a limited screening. So the landlord isn't allowed to screen guests for credit or income, but can screen for things like past conduct. Or a landlord could require a 15-day or greater guest to enter into a temporary occupancy agreement, but the landlord can't restrict that temporary occupancy agreement to end before the end of the grace period in the end of February. Senate Bill 282 extends what has been a COVID era protection relating to retaliation. The legislature increased penalties related to retaliation during this time. Landlords are not allowed to limit services or retaliate against renters who have paid rent, or I'm sorry, who haven't paid rent during this time, who are otherwise asserting their rights under the grace period or the moratorium, or the 60-day pause, or any of these new protections, or frankly, any protections at all under landlord-tenant law. The penalty for retaliation is up to 3 months rent or 3 times actual damages, and retaliation is a defense to an eviction. This increased damages amount will sunset and will revert back to the typical penalty amount of 2 times rent starting in March at the end of the grace period. Here are some resources. Again, there's the link to look up by county where someone's local legal aid office is, and then also the number for the Oregon State Bar Lawyer Referral Service for in this area. And now I'll stop for questions. I have no idea how I'm doing on time. It looks like we do have a little bit of time. It's just about 2 o'clock to maybe bring some questions that have come up in the Q&A into the discussion.
Okay, I think I have a couple of questions that I sort of noted down as being consistent questions. So I'll try to call those out, and then Kate and Becky, you may have points that you have in the back of your mind, just kind of wanted to go back to, but I'll just kick us off and get started. And so one question that came up several times was, I think for Becky, and that is, what about late fees after July 1? We know that the protections of the eviction moratorium that has been in place since the pandemic has prohibited the assessment of late fees during the moratorium period. And we know that those prohibitions on late fees continues to apply to the grace period debt. Any of the debt that was accrued during, it was protected by the COVID moratorium that now has a grace period to the end of February. No late fees may be assessed on those debts until, if they remain unpaid after the extermination or expiration of the grace period. But what about July 1 and moving forward? Can late fees be assessed on rent if it's not paid on time in July?
The answer is yes. I think starting July 1, we're kind of back to normal times, except for the protection of Senate Bill 278. But rent is due, late fees begin to accrue, I believe, on the 4th day of the rental period after rent isn't paid. Notices can be given starting on the 8th. Again, this is kind of underscores the reason why tenants should take advantage of the Senate Bill 278, but those late fees accrue.
Thank you. And it's another reason why we encourage tenants, anyone who thinks they are not going to be able to pay rent on time in July ought to apply for rent assistance ASAP. And when rent assistance payments are being assessed and determined and figured out, late fees, if they exist, can be a part of that consideration. And so really, just the sooner you get your rent assistance application in, the better. Everyone should go to 211info.org or to OregonRentalAssistance.org to get that process started if they haven't already. Kate, do you want to add anything to that?
No, I couldn't have said it better myself. Thanks, Sybil.
Okay, so the next question came up, I think, again, is to Becky, related to what happens if a tenant applies for assistance and then they receive a termination notice from their landlord, they provide documentation of that application. What happens if the application is still pending after 60 days? Can you talk about that?
I think that's a situation that we hope not to be in, frankly. The landlord under the law is permitted to move forward with the eviction process. The law does not require that there be a determination on the rent assistance eligibility of the rent assistance application in order to move forward. So that may still be pending at the time, and it can move forward.
Thanks. So just to reiterate, if once the tenant provides that documentation to the landlord, for example, in response to a termination notice, there is a 60-day pause that would prohibit the landlord from filing an eviction proceeding based on that notice. If the application is not determined and the landlord is not paid within that 60-day period, the landlord may move forward with the eviction. Hi, Laura. Glad to have you, everybody. Laura Lean is with Oregon Housing and Community Services, and thanks so much for joining us. We're grateful to have both you and Kate here. So we're just going through Q&A now, obviously, and I'm trying to do a little emceeing, and then I'm going to turn it over to folks who just may, to our presenters, in case there are points that people want to just hit on. The next question that I noted, I think, is a question for Kate and Laura, related to, does rent assistance cover utility payments? And can you talk a little bit about that?
Great question. Kate, I'll jump in and then you can fill in the blanks. The rent assistance is primarily what we should be covering with OERAP, but there is a utility assistance provision as well. So both arrearages and forward payments on rent and utilities can be covered by the program. One caveat, and this is outlined pretty clearly in our program guidance, if the rent covers a part of the utilities that are still remaining outstanding from the rental agreement are the only payments we can make in terms of utilities. Hope that helps.
Yeah, I just wanted to say I should have covered that in my opening, but with jumping in, I just glossed right over it. So thank you for whoever asked that question, really important point. And thanks to Assistant Director Laura Lean, who just jumped into the hot seat of all the questions. So welcome.
We are all, and throwing this together in a very short period of time. So it's moving quickly, and thanks to the participants all for making time. Another question that came up has to do with landlords who have applied for the LCF. So they may be waiting on determinations, especially since that fund, the last round just closed last week. And so I think there's some confusion about, if I have an application pending with LCF, do I still need to participate in a tenant's application for ORAP? And I'll tell you my answer first and then throw it over to everybody else. But the answer is unequivocally yes. The LCF only applies to back payments and cannot cover forward rent. The emergency rent assistance program can cover up to 3 months of forward rent. And so there's just a vast difference. And if a tenant is in need of forward rent, that's the only avenue that they have. LCF is not an avenue for that. I also would flag for landlords that source of income discrimination protections apply. And so that's something certainly that would need to be assessed by any landlord making that determination. And emergency rent assistance provisions, programs do provide that if there is not a participating landlord, that an eligible tenant is entitled to have payments made directly to the tenant. So all of that needs to be taken into consideration and valued deeply. And I guess the only other thing I would maybe ask specifically Kate and Laura to weigh in on is, how is it that duplication of benefits is handled in that scenario?
I can jump in on this too, Kate. I don't want to steal all of the thunder from OHCS. So if you ever want to take one of these questions, please interrupt and take it away. But generally speaking, the duplication of benefits question has come up quite a bit. And so one thing that we're working on behind the scenes between LCF and the OERAP program is looking at matching addresses, just to ensure that anyone that's coming through our system on the LCF side isn't necessarily a red flag for anyone on the OERAP side. There's also specific language in both of those portals that outlines what will happen if, say, a landlord applies for the LCF fund and receives it in the meantime when a tenant had also applied for OERAP and receives those dollars. So we do have protocols and procedures for returning funds one way or the other. Additionally, within the OERAP program, the processors can change the either the accrued rent, so the arrearages, or the forward rent payments accordingly. So as long as that check hasn't been processed, if a landlord knows right away that they've been a recipient of LCF, they can let their tenant know, and the tenant can follow up with the Community Action Agency or the PHA in their region, and they can convert some of those dollars to forward rent. So to Sybil's point, we want to ensure that tenants are not only covering back rent and becoming whole from arrearages, but are also obtaining as much forward rent as possible to stave off any future evictions. So I think that dance in the middle is really the critical piece to consider here. And we're always open for questions on that on the OHCS side.
And just for context really quick, the Landlord Compensation Fund, as folks may or may not be aware, didn't have income limitations, but the final round 3, closed last week. And so it is now ended, although public housing authorities are processing those applications and payments. So compliance is continuing, but LCF has now closed.
Okay, so I'm going to put the call out to everybody for any other issues that they want to come back to, and I just have one more question, and then we can start wrapping up. But the question that came forward is for OHCS, and again, I think we were also jumbled as the beginning of this got off, that I missed maybe the numbers, sort of how much money do we have in Oregon right now available through the Emergency Rental Assistance Program, and how much do we expect to come down in the next couple of months, if you can sketch that out.
Sure, I'm happy to take this one too. I keep looking at Kate, wondering if she wants to jump in. So currently for ERA Wave 1, which is what we're currently implementing at this point, is $204 million. And that is expended across the state by a funding formula. And so the allocations that each region received is contingent on the data that we have available to us around the overall need. We are looking and maintaining very close eyes on that spending, what the spending trends look like, who is overspent, who is underspent, and we will be moving dollars accordingly and supporting those community action agencies that might be looking at being overspent with ERA $2 as well. So that 65% expenditure deadline that the US Treasury imposed on the state of Oregon and every other state, it's not just ours, by the end of September is something that we're paying very close attention to. ERA 2 is likely to come on board end of summer, early fall, and I think we have a $155 million, give or take, for the second wave of ERA 2 funding. It would be good to note ERA 2 funding is a little bit more flexible than ERA 1 funding. So we're also looking at some capacity building opportunities, and we're also looking at some housing stability service dollars going out to different organizations across the state that can support tenants remaining in their homes and can support landlords receiving money that is due or that will be due to them because of the COVID pandemic.
Thank you so much. Okay, so I think just one more question came in. I lied. I saw one more that I'm going to ask Becky to answer, and I think I just forwarded it to you. Do you get it, Becky?
I didn't get it, but let's give it a go.
Okay, well then I will try to repeat it. So the question was, what if a tenant has applied for rent assistance, not through ALITA, not through the state, but from a smaller program, and maybe not even from a community action agency, maybe it's from a church or a small nonprofit. How would that work for tenants? And does the bill still apply?
The bill does still apply. The bill kind of limits the application of this protection to rent assistance providers, provider kind of being the key word there. So I think a nonprofit, any sort of kind of like organization that's providing rent assistance to people would be subject to the requirement to give some sort of documentation, and then tenant would be eligible to use that documentation to apply for the 60-day pause. I think the only piece that kind of wouldn't really qualify would be sort of like an interpersonal money lending, like a family member or a friend isn't really a rent assistance provider. But other than that, I think an organization counts and can be used to get the 60-day pause here.
Okay, thank you very much. So I think that those are the questions that have come forward as themes. And unless any of our presenters have any other topics they wanted to hit on before we close, give folks a minute.
Thank you. I really did want to emphasize a few points that I just jumped in and may have forgotten. One of which, it's really important for folks to know that immigration status is in no way a part of this application, and that all Oregonians are welcome to apply. And we really appreciate everyone on this call and your willingness to spread the word about the program. I see someone had a question about a flyer. I'm going to go ahead and send the Dropbox link to Becky and Sybil along with the social media tiles to distribute. I can't seem to add them on the chat myself, so I'm going to send them their way to share out into the world. But again, thank you, thank you, thank you for spreading the word about emergency rental assistance.
And thank you so much, Kate, for mentioning the immigration status point. And just as a follow-up to that, to add on, we are also wanting to make sure that the community understands that there are no public charge consequences to anyone without legal status who seeks and applies for or receives rent assistance through any of these programs. So immigration status is not a barrier. It is not relevant to, it's not requested or asked about in any of the applications. And if someone without legal status is a recipient or an applicant, that does not have any immigration consequences to them down the line. So thank you so much, Kate. I feel remiss for not having mentioned that up front, so thanks a lot. Okay, well then I think that can bring us to a close. We know that there are more questions, and we will, some of them require further thought that I think can be useful in a quick chat response. So we will be sure to go over those. We will send you the recording of this webinar, also Becky's fabulous PowerPoint, the link to all of the materials that Kate and Laura and OHCS have provided to us, and a summary of the Q&A. And we encourage you to review those, share those, post those, make them as widely available as possible. And thank you so, so much for your time today. And with that, I think I will close the webinar. Take care, everybody.
Thank you.